suspension, there is no summary review. You have to have a hearing. If you want to challenge it, it's your only way to challenge it. If you don't do this, if you don't properly and timely file either a request for hearing or the summary review request, after 15 days, your license becomes suspended, as indicated on the document. 16th day, there's just no exceptions. MVD is very strict about that. Between hearing and summary review, tough decision to make. Definitely talk to a lawyer before you make that decision, because there are advantages and disadvantages to both. And if the license suspension is a really big deal to you, you might want to do one or the other. But definitely talk to a lawyer who handles this type of law, because sometimes summary review is a great decision, and I've had it work very, very effectively, but it's not the most common decision, and it can be a big mistake to file it if you have a weak argument, because a judge may review it and not ask you any questions because you're not there, and they may just deny it. The hearing is way more open. You get lots more interaction with the judge. The witness, the police officer does have to show up in person, or however the judge allows, but they have to show up and testify. So the hearing is a lot more dynamic. While that's happening, the criminal case is going to proceed. So you may want to challenge your license suspension. You may not. You may want to challenge a criminal case. But those two things are operating absolutely separately. So it's really important that you understand both have to be addressed at all times. Neither one is going to delay the other. Jurisdictions for DUI case. It depends on the misdemeanor or felony charge. If it's a misdemeanor charge, it's probably going to be in one of the justice courts, which are county courts, or a municipal or city court. They all handle misdemeanors. If it's a felony and it proceeds as a felony charge, it's probably going to be in the county superior court. So Coconino County Superior Court, for example, would handle all aggravated DUI cases through completion. The Arizona Rules of Criminal Procedure will apply, so that gives you some safety net as to due process and making sure that the cases are consistently processed. Two quick questions about the right to an attorney. You have, first one, do you have the right to an attorney? The answer is, with a criminal charge, DUI, or any criminal charge, you're guaranteed the right to have an attorney, all right? So you can have an attorney represent you with any criminal case, no matter what the charge. That's a constitutional right that you have. Separate question, so do you have the right to have an attorney versus do you have the right to have a court-appointed attorney, a public defender, a lawyer appointed by the court, paid for by the court or the county or the city in order to represent you? Interestingly, with a DUI case, the answer is always yes. And the reason is this decision is made based on whether a person is facing possible jail time. So if a person is charged with, for example, shoplifting, and it's a first offense, they don't have the right to have a court-appointed, a public defender, represent them unless the prosecutor comes to court and says, Judge, the state is asking for jail time, so you're going to want to appoint this person a lawyer. That's what triggers the right. In a DUI case, because the minimum penalty, even for the slightest degree, lowest level DUI, is 1 day in jail, that guarantees, no question, you have the right to a court-appointed attorney if you cannot afford an attorney. So a judge would ask you about your finances and decide whether you have the funds to hire a lawyer, and if you don't, then they will appoint you a free lawyer every time. So the gist of that, or I guess the summary of that, is always have a lawyer. There's no reason to not have a lawyer on a DUI case. You need it. It's a complex area of law. You're going to do better. Your odds of doing better are way, way better if you have an attorney. And if you need a court-appointed attorney, just ask for one. But you're going to be a lot safer having one. There are just too many legal issues at stake here, and your freedom is at stake. So it's really too significant of a kind of case to represent yourself, even though you have the right to do so. Mandatory minimum sentencing. Every DUI has jail time. So the slightest degree is just that 1 day. Bump that up to a first offense aggravated DUI. You have to do at least 4 months, and that's not in the local jail. That's 4 months in the State Department of Corrections. So the state prison system. So everybody has different ranges. Every type of DUI, I should say, has different ranges of mandatory minimums, but every single one of them has some jail time. So always consult with an attorney about that and about the steps I'm about to go through. Processing. So you've been arrested for DUI, you've been charged, you're going to have an initial appearance, and at some point, possibly the same time or later, what's called an arraignment. The purpose of the initial appearance is simply for the person to be advised by a judge of their charges. So if you're arrested, you're going to see a judge while you're in custody. You'll probably be in the jail, and they'll video conference you into a courtroom, or they may physically bring you over in shackles to a courtroom. But ultimately, the judge will advise you of your charges and then decide whether to release you with conditions, or to impose a bond upon you. So generally, a first offense DUI, you're going to get released one way or another, generally speaking. Second offense, third offense, felony DUI, you have to be concerned because they may impose a bond at that point. It just depends on the conditions that the judge feels are appropriate, and it depends on your unique circumstances as a person. Arraignment. So what normally would occur there, which is pretty basic, is to review the charging document and to enter a not guilty plea. Almost always. I mean, it would be very, very rare that a person in a DUI case, other cases are totally separate, in a DUI case, it would be very, very rare where entering a guilty plea would be the appropriate move. So it's a very unique circumstance when we would do that. We would do that only strategically if it helps the defendant, if it helps our client, for example. And there are some times that actually is true, believe it or not, but that's complicated and it's strategic only. Generally speaking, everybody's going to enter a not guilty plea. And frankly, even if you try to enter a guilty plea at your arraignment, most judges are going to tell you if it's a DUI, stop, I'm not going to accept your guilty plea today. You have the right to a lawyer, and I really hope you talk to a lawyer because you need to reconsider. So most judges are aware of this as well. After the not guilty plea is entered, the case proceeds on to the next step. And in some courts, in fact most courts, they're going to call it a pretrial conference, or PTC for short, and that would be on almost all misdemeanor cases. And that's because the Arizona Rules of Criminal Procedure talks about pretrial conferences. The other type of conference you may see is what's called a case management conference, and those are typically used in felony cases, and they tend to involve the judge a little bit more. So the more serious the case, the more likely a CMC, or case management conference, is going to take place because the judge is a little bit more involved. Pretrial conferences, we'll talk about what those are in just a moment, but they're a little less intensive and the judge is a little less involved. Viewing the evidence, a big question, which is called disclosure. The evidence in your case, according to the rules of criminal procedure, is called disclosure. A lot of questions I get are, when can I see the police reports? I don't think he got it right, or I think something happened that I want to review. So a big question is, when can I have my disclosure? The answer under the Arizona Rules of Criminal Procedure is, you can have your disclosure. The deadline for the state or government to give that to you is at your first pretrial conference. So you're going to do your initial appearance, you're going to do your arraignment, and then in a misdemeanor case, you might have to wait until your pretrial conference in order to get that disclosure. If you have a lawyer, they're probably going to get it sooner, so we'll get from our local prosecutors, we'll get our disclosure for our clients far in advance of the pretrial conference, but that's by way of agreement that maybe they can email it to us. They now have e-discovery or electronic versions of the discovery. The good news is they've been getting it out faster. So if you're representing yourself or you have a public defender, maybe you haven't met them yet, the pretrial conference is when you can expect to see that. That's when you would get that information. PTC, or pretrial conference, assuming you have an attorney, which again you should, at least consult with an attorney, but you should really consider having an attorney. The pretrial conference is literally a conference. It's a meeting between the prosecutor and your attorney. In other misdemeanor cases where a person has no right to an appointed attorney and they choose not to hire one, you would meet with the prosecutor yourself. In a DUI case, it's almost exclusively lawyers meeting with the prosecutor on the case, and the purpose of it is just to make sure I got my police reports, make sure I can convey to the prosecutor the favorable things about my client, the favorable things about the case from the defense perspective, issues maybe that I see in the case. So it's just a meeting. The judge is not heavily involved. They may be around the courthouse. They may have you tell them what you're doing or what your plan is, but they're not involved in the discussion itself. Every court's a little bit different. CMCs in the Flagstaff Municipal Court, for example, will take place after a pretrial conference, and the judge is just a little bit more involved at that point based on case processing requirements, scheduling, and dealing with substantive issues if there is any dispute between the prosecution and the defendants. Here, several courts would process DUIs. Felony DUIs are going to be most likely in the Coconino County Superior Court. They also can start in justice court, but typically misdemeanors will be processed in the county system, which is Flagstaff Justice Court, Williams Justice Court and Page Justice Court, as far as Coconino County goes, just for Coconino County, of course. And then in the city court as well, the Flagstaff Municipal Court processes almost every DUI charge that happens within the city, except the ones on NAU campus. Those will be referred to the county court, Flagstaff Justice Court. There's one other court here that we didn't talk a lot about, and that is the United States Magistrate Court for the District of Arizona. That's a federal court that can process DUI charges, and those do happen at Wahweap, at the Grand Canyon. Because of our jurisdiction here in northern Arizona, we do have a lot of national parks. It's just one example of where a DUI might happen. Someone's driving under the influence around the Grand Canyon area or within the national park, which is very big, has a lot of roads. That's going to be processed actually in the federal court. And it's processed very similarly, but there are some distinctions. What about appearing for a hearing? Really important to ask your lawyer. You might not have to go to those pretrial conferences because you might be sitting in the hallway thinking what's going on while the lawyers are meeting in the back room anyway. And the prosecutor doesn't want to meet and talk openly necessarily with the defendant there in a DUI case because they can't take statements. They're not investigators. And if they hear the defendant say something, the prosecutor might be a witness to that statement. So the prosecutor may be conflicted off of the case. So they very much prefer, pursuant to the ethical rules as well as just processing of cases, to just meet with the lawyers and not have the risk that maybe they overhear something that the defendant says. They don't want to be involved. They want you to be able to talk to your lawyer privately. They don't want to be listening in. So it's just a lot cleaner. But ask your lawyer. Sometimes it's favorable to show up. Other times you might as well go to school or work or do something productive while your lawyer takes care of what they're supposed to be doing. After the pretrial conference or the case management conference, there could be several of those, by the way. But once the case reaches a boiling point, so to speak, it's either going to resolve with a trial or without a trial. And there are a couple of ways that can happen. Without a trial, dismissal, the best one. You won. Or a